watching Business Television India.
Hello and welcome to Business Television India. I'm Siddharth Zarabi and you're watching our special Mission Cleanup, 12 months, 12 companies. It was 12 months ago on the 12th of June that 12 of India's largest debt defaulters were dragged to insolvency by the RBI. Dozens of other defaulting companies have since been frog-marched to the company law tribunals across the country, with as many as 75 of them being listed firms at last count. 1 year down, the results are mixed. 2 of the 12, Bhushan Steel and Electro Steel Steels, have been resolved. Binani Cement, SR Steel, JP Infra, Bhushan Power and Steel are held up due to some legal challenges. 2 other firms, Era Infra Engineering and Jyoti Structures, are still within the 270-day deadline for resolution, while Alok Industries and ABD Shipyard, by some estimates, are pretty close to liquidation. On today's show, the anniversary special of the Big 12, we ask these big questions. How has the insolvency process panned out over the last 12 months? That's question number 1. Can we expect lesser litigation and delays going forward? That's question number 2 for today's special debate. Will the recovery go up or decline? Will the quality of bids improve? That's question number 3. Will the next 12 months be more about liquidation and lesser resolution? Crucial question, because let's not just get misled by some of the bigger bids that are coming for the more prized assets. 5th question, will the changes help lenders maximize value? There are many more questions, but for now we'll focus on these big 5. And joining me on the show today to discuss these questions and many more are Alok Dheer, Managing Partner, Dheer & Dheer Associate, Shutanu Sinha, Partner at BDO, Ashwin Bishnoi, Khaitan & Company, the Liberty House Council, and R. Gopalan, former Secretary of Economic Affairs, also with us on the panel to give us an overall assessment from a policy-making perspective. Thank you very much, gentlemen, for joining us on the show. Before we head into some of the crucial questions, I just want to play out on the screen some basic graphics just to put it all in context for our viewers. So the insolvency report card, if we were to call it that, and this is not just the 12 companies, viewers, it is the overall sort of main statistics around insolvency so far. Cases as admitted so far 701, resolved out of that 22. This is data sourced from the IBBI. Commencement of liquidation for 87 companies. 525 are still undergoing resolution, and closed on appeals 67. And just to give you one more flavor to that data, the initiation of corporate insolvency resolution process, operational creditors have initiated more insolvency than financial creditors. Of the 701 resolution processes initiated that we just spoke about, as many as 262 cases were initiated by financial creditors, 310 by operational creditors, and 129 by corporate creditors. And finally, coming to the core of our show today, 12 months, 12 companies as we are calling it, 2 of the dirty dozen cases have been resolved. A couple are headed for liquidation, but the key headline really to absorb at this stage, of the 3,20,000 crore of debt within these 12 companies that was sent for resolution, by various estimates, around 1 lakh crore or a little bit more is likely to be recovered, which means roughly a 1/3 recovery. It could change a bit. We know that 35,200 crore has come from the Bhushan Tata Steel deal, another 5,320 odd crore from the Electro Steel Vedanta deal. There are many more to come, and later on during the show, I'll also give you the NCLT status report for the first 12 companies, which are the crucial companies. So let's get into the debate right now. The questions are there for everyone. I'm going to start with Shutanu, who, by the way, viewers, is also the resolution professional for IVRCL, which is one of the companies, and therefore he can provide us an absolutely sort of grounds-up view on this. How has the insolvency process panned out so far, Shutanu?
Siddharth, this is really interesting that country has a new format today. It was not like that previous days that you have so many options, say you are going for CDR, you are going for some administrative restructuring, whatever not. But to address the problem per se in a concerted way, in a all-pervasive way, this is the best format today we do have. And whatever criticism are there, criticism must be there to improve the system and the process. But one thing everybody is accepting, everybody is of the same view that yes, this format is trying to solve the problem and trying to bring out the reality, what is exactly state of affairs of a corporate and where do I stand as a corporate, whether the corporate is sustainable or not, whether it would run or not. It is coming out in a very, very transparent way.
So transparency is one of the key things. I'll come to many of the other points that you have mentioned in the second round of questioning. I want to come to you, Alok, for the second question of the day. Can we expect lesser litigation and delays going forward? And this question is also in the context of the Second Amendment ordinance to the IBC.
As one would say, and from a lawyer's perspective, it is the right of anybody who feels that he is affected prejudicially to file appeal or contest the matter in courts. You can't take that away. And in any such situation in IBC, there are going to be parties whose rights are affected. And therefore litigation is there to stay. We shouldn't shy away from it. However, the litigation is twofold. One is establishing the procedures and the processes of the IBC. Early days, it's been about a year, and many of these 12 cases have suffered an enormous amount of litigation, but at the same time, the jurisprudence is being established through these cases. And once the jurisprudence...
So the manthan is happening, so to say.
Absolutely. So once the jurisprudence is established, the processes are established, the proceedings are established, there will be lesser litigation on these issues.
So the coming year will be better than what...
The coming year would see that the process-related litigation will come down, but the litigation relating to the prejudicial effect on the rights of the people will continue. And as larger and larger number of companies come under the fold of IBC, we will see that the litigation will carry on and continue, and it's nothing to be shy of or be afraid of. It's part of the process.
It's part of the process. Brilliant point. Third question, and I'll come back into some of the finer points. I quickly want to do a summation and to you right now, Ashwin. The third question, in your assessment, will the rate of recovery go up or decline? Will the quality of bids improve? This is not just because of the kind of companies that are now up for resolution, but also perhaps after effect of the second IBC amendment ordinance.
Look, I think the law in itself has only so much of an impact on the recovery rate. Ultimately, recovery is a question of how much leverage is on the company, whether the company itself is viable or not. So I don't think to say that the law will have a positive or dispositive impact on recovery is a fair statement. That said, there have been various changes that the law has made which I think are designed to have better recovery. First and foremost, in the earlier avatar of this law, the liquidation value itself was disclosed. Now, when you disclose to everybody what's the bare minimum that they need to quote, everybody is going to quote above that. So I think doing away with that has resulted in a more transparent mechanism.
Doing away of the liquidation value being disclosed to all bidders, does that apply to existing cases? Is there a cutoff? Can you elaborate on that?
It applies to cases going forward, and this was brought in by the law some time back, so it's not a new animal in the ordinance. The one thing that this ordinance does, which I think we'll have to see how it pans out, is that when it comes to real estate companies, it now recognizes home buyers as financial creditors. So the liquidation report goes to financial creditors. So if you take the example of JP, if you send the liquidation value and its report to 1 lakh people, how do you then maintain the confidentiality of that number so that tomorrow's bidders don't then bid 1 rupee more than that?
So perhaps some of these issues will get addressed in the regulations that are to be issued by the RBI. Mr. Gopalan, we sort of picked up some of the issues with actual practitioners, and all three of them have hands-on experience with it. Now, from a policy making perspective, have you ever heard of the fact that in a year, any sort of resolution, and we have had different kinds, BIFR and other provisions, which has brought India close to getting $15–17 billion of recovery in 1 year from just 10–12 companies. Isn't it amazing?
I think this is policy-wise, I would say this is one of the best things that is available at this point in time in the country. We tried a number of things, SURF-AC, we had DRT, everything we tried, but we could not go forward in such huge manner as we are going forward at this point in time. So, in that sense, this is a very good thing to do. Should have been done long ago, but the fact that it has been done now and we are going forward in this is a very, very important policy measure as far as the entire financial sector is concerned. Yes, any process, any new thing will have teething problems, interpretations, people who give up, who have to give up their whatever hard work, whatever, they will keep fighting. It's not that it's not going to go away. But as has been pointed out, the procedures, if the processes and if jurisprudence are going to kind of settle in, then the fight is only going to be those who feel they have been deprived. That's where the fight is really going to be. So in that sense, a stability to the
and the courts haven't been emotional in this regard. They haven't really sided with a promoter who has been suspended from management control of the company, right?
Yeah, they take a legalistic view. I mean, I would say that they're taking a legalistic view. Where is the question of any emotion playing in this at this point?
Okay, now let me ask you an emotional point, Mr. Gopalan, before we continue our second round. And this is from, because you have also dealt with banking for many years in your career. I want to ask you, the real story is the right back story of that is happening, and markets are enthused, investors are enthused. Perhaps in the next quarter and 2 quarters, we will see that pan out. But there are cases, Mr. Gopalan, where we have learned, not just in the big 12 that we are talking about, other cases where lenders within the COC, representative of the banks, many RPs have told us that the banks are not being serious, they don't want to take any tough decisions, they are leaving it and they are preferring liquidation in certain cases rather than taking hard and tough decisions because they are scared of the consequences that may be visited upon them as bankers. Is that something that you feel has not been addressed so far?
I think the bankers have not really fully understood what is going to happen if they prefer more liquidation to resolution. Okay. Liquidation also can be examined by whoever agencies, whichever agencies are going to examine, they can examine that as well. Okay. And if as a result of liquidation you are getting a much lower value as compared to what the resolution was going to fetch you, somebody is going to really pay for it. A resolution comes out of a very transparent process of bidding. You can improve the process of bidding, like in telecom you have done multiple rounds of bidding, you can do that. That you can do to maximize. Therefore, the disincentive for liquidation has to be higher as compared to any incentive for your resolution.
Should we also be emotional about the fact that liquidation will mean loss of employment perhaps? And now if you answer that, then I'll go across to the people.
Liquidation has a lot of problems with that, not only loss of employment. As an economist, I feel that the potential output of the economy goes down if many of these companies are getting into liquidation. Even today, the fact that these companies are not producing today, that depresses my potential output in the economy. Now, there is a chance that they may come back, just with the flip of a coin, they can come back. Now, if you go into liquidation, it's lost.
Absolutely, the headline number gets lost. Shutanu, I want to come to you. Beyond steel and cement, many companies, and I'm not asking you to talk about those that you are handling, so we respect that. Other companies, it's very clear, are not getting good bids, both in value terms and from good serious investors. Why is that so?
Siddharth, this is, there is a market driven. The way I understand this thing is that one way there is an offer in the market that these companies are ready for sale or say for restructuring under IBC. And it is definitely, it is investors' choice that whether they would come or not.
Is that your experience, that market realities are driving these values?
Definitely, it is market reality is one of the factors, and second factor
it is not a case where the bidder is seeing the desperate situation and is trying to drive a hard bargain?
You know that Indian market has not been matured in this field so far.
As far as price discovery is concerned?
Price discovery and also the stress asset handling. Our economy is very new to this. So over the years we would be understanding this thing, we would be learning, because we are building expertise in this field now. We don't know, many companies are there, maybe apparently it is appearing to be non-functional or something like that. But in reality, maybe it's a gold mine. What Sir also said, that we are not deciphering the thing in a very professional way, I believe. And secondly, what I feel that this companies, when we assess or we analyze the company, we go for in a very traditional way of understanding the company. What I said earlier also, that first point you need to see the company whether it is sustainable or not. Whether it would survive over 10 years or 15 years or 20 years.
But you as a resolution professional are supposed to be competent in doing that.
That is, resolution professionals' functions are very much defined in the law. So I'm not as resolution professional.
Let me ask you a pointed question before I go to Alok. Tell me, again, without reference to your cases, but general observation, have you felt that bankers have been less than enthusiastic in the meetings of the COCs to resolve those companies? Is there a fear factor?
No, I would not say in that way. Like the law, like the resolution professional, like the companies referred to, bankers are also new in this field. So they are also learning.
But how can they be new? When they gave these loans, they were not new. When it comes to recovery, how are they new?
No. In this case, it is not a case of recovery. The first thing we are missing.
It's a resolution. I get that. I mean, bottom line is recovery.
People are thinking that it's a recovery exercise. It is not like BFR case or other cases. It is absolutely different. It is resolution. Means bringing the company into main track.
I agree with you. I agree on that. Alok, I want to come to you because, you know, of the points that through this 1 year and through these 12 companies, do you think there are signs of the Indian market for distressed assets coming of age, both in terms of jurisprudence, process, as well as value discovery?
I would say absolutely yes. I think it's been a very important thing. When the 12 cases came in, everybody was very skeptical about what would happen and how there would be price discoveries. All these assets are now in the market and processes were not established. But over the last 1 year, we've established processes to quite a certain extent. At the same time, there is a lot of interest in the market, and these were very iconic assets. So a large amount of capital started chasing these assets, and much of this capital was foreign capital. So many investors have come forward, and therefore it has made India into, I mean, we've got, as typically as one would say, a sale going on with respect to industrial assets in India, and everybody will come and mention
of corporate assets
ever. So I think that's going to attract a lot of capital. But before I say this, let me just reflect on something that was put as a question to Shantanu. Why are we not getting bids for smaller cases? And let me just analyze 3 or 4 reasons which I believe.
Very important. Let's also play out the key impediments on screen while we talk about why certain bids are not coming. Let's bring that graphic up about the key impediments, which includes objections of all sorts. Alok, go ahead.
Let me just look at it from a very commercial standpoint. The first issue is that there is no takeover financing for small and medium sector companies. You don't have foreign capital, you don't have private equity coming in, banks are not lending. So you are expecting small, mid sector and small assets for promoters to bring the funding to acquire this. Not the best thing to do. You don't have the same opportunity as you have for large assets where big capital chases it. So one, there is dearth of capital. So there's nobody putting in money. The second issue is the uncertainty and the lack of sophistication amongst the prospective investors. They don't understand the process. They don't understand due diligence. They don't have the financial sophistication to take over assets of this nature. And they are a lot of uncertainty. Even today, we don't know what is going to happen with statutory dues. So a person who's going to put his own money and not money which he has co-invested with some investor has a much lesser risk appetite. So he doesn't want to put in that money. Then there are the legal challenges. Another very important issue is the smaller companies do not have what are called licenses leases which are, or let us say a mining lease is attached to a large asset. So there is a great deal of, that if it is in restructuring, you'll get the license and the lease will continue. You go into liquidation, there is no lease or license which will continue. So the value that they will get in liquidation is far better for an acquirer than what he will have to pay for in case of restructuring, because there's nothing that is available in restructuring as a lease or a license or a government approval or a certification, which he will miss if he's going to buy that asset out merely into liquidation. So he'd much rather wait for that. He'll get a cleaner deal. There will be no liabilities of any nature attached to it. So these are some of the reasons I believe that is the reason why in small cases you are not getting enough and adequate bids, and somebody will have to address them very seriously. It's not just 29A keeping the MSME out of 29A that is going to help. So this is something that we'll have to go in deep down and understand what are the reasons why this is not happening, and then perhaps try to ameliorate them.
Absolutely. Ashwin, I want to come to you, and because we are discussing two cases which are pretty much while our discussion is going on, I want to take one example of Ruchi Soya, where there is a face-off that is being done between the two bidders, between Patanjali Ayurved and Adani Wilmar, and the H2 will be given a chance to match H1. I don't know how many rounds of that will happen. It's not very clear, it's not been spelled out. But the question that arises from there is that, is a open bid system with auction virtually the best way to go to maximize value for this during the resolution process?
So I wouldn't want to talk about a specific case.
Sure.
I think your general question is well taken.
I can take the names, you can give us the answer.
Look, I think as other panelists have mentioned, this is not a law only for maximization of value in the hands of the financial creditors. No doubt they are the ones who have the biggest stake. So to say that you run an open auction where you just compare numbers to numbers, I think would be doing a disservice to what is the intent of this law.
Okay.
The intent of this law is to protect, let's take the example of home buyers. Do you give possession? Do you not give possession? Do you give late interest payment? Do you not give late interest payment? Who is the best developer to construct the common area?
Correct.
So to just compare numbers to numbers is not the intent of the law. That is effectively how it is playing out today. I understand that. And look, at the end of the day, numbers will always lead.
Will more of this happen? In other cases, in NCLT 2 cases, or even the cases that will be the next wave that is coming as a consequence of the February 12 order, will more of this happen, this sort of quasi-open auction, Swiss challenge, whatever you may call it, system, where face-offs happen between the bidders at the behest of the COC?
Look, this is my personal opinion. Sure. I am personally of the view that some sort of process needs to be respected. I am not for a minute suggesting that the law or the regulator prescribe that process. Why tie the hands of the resolution professional? Let him decide for himself which is the best process by which you derive maximum value for creditors and the best resolution applicant for the asset.
On that, I have to come to you, and I've asked you this question in the past. Shatanu, one quick comment and then to you. We discovered in the sort of round so far that different RPs interpreted the same clause differently, just like various NCLTs had different interpretations. Is that going to continue, or is there greater uniformity in RP's decision making likely? You first.
I believe that it is getting streamlined over the years after several NCLT judgments on many matters.
And the appellate tribunal judgments also.
Gradually it is changing and consolidating also. And you know that RPs, they try to interpret within the law. So the law is, this law is open-ended a little bit. Open-ended in the sense that
the only thing that was not open-ended was the 270-day deadline, and that has been open-ended fully now.
No, but you have a lot of creativity you can put in the system within the four walls, and you can bring the best resolution.
So RPs need to be very brave people, because if a banker can be questioned post a deal, so can a RP. Alok, a quick comment about that.
In fact, I think the responsibility on the RPs is becoming more and more steep, and it is going to become very difficult to discharge the obligations of being an RP as at the same time, you know,
also
keep your equanimity.
It will become very difficult also in the cases where upon discovery it is found that there is nothing left in the concern virtually, and it will receive pittance of bids, and there will be a hazard in decision making. Therefore,
I don't know. If there is nothing there, then there is no hazard in decision making. But the reality of the matter is that the responsibility.
No, without taking names, there are a couple of companies in the Big 12 also where such concerns have come out. Yeah, Alok, maybe you. Yeah, sure.
No, we know them.
The market knows them. We know them, but we don't want to make wild allegations. Ashwin.
But so we talk about liquidation, right? I don't think. Look, every religion requires a hell. Every law, every insolvency law requires a liquidation. That fear factor needs to be there, which will propel people to act in a manner which is economically viable to revive a company. If a company should go into liquidation, that is an economic reality that you have to accept. It means that rather than getting zero recovery, you will at least get some recovery, hopefully.
Okay, those are important points. I want to bring up one more concern that has come up, and you know, a lot of people are writing into us on our social media profiles, and they are asking us to raise this question. So on behalf of all the viewers, I'm just touching upon this question in our final round on this show. This is the no exit option for shareholders issue. I don't know who has come across this. It's already known. Minority shareholders in several of these companies are being very voluble about what they say is that they are getting an extremely bad deal, a raw deal. You know, and the issues that these shareholders are confused about is where is their standing in the insolvency process. Many of them are arguing that, you know, we should also be treated and given some sort of assured status. They are saying that in case the company remains listed, there is hope for a better exit, but in case of a delisting, the shareholders claim that they are completely at the mercy of the acquirer. So the instance that is being given is that of Vedanta deciding to delist Electro Steel shares at rupees 9.54 per share, and therefore the 80% value erosion for shareholders that is being witnessed in the case of Electro Steel, for example, and I'm just using that as an illustration to raise that there is one more point about no exit options for shareholders. Basis this, Mr. Gopalan, I want to ask you a question. Can a law like a IBC keep addressing different constituencies? It almost seems like politics. You keep addressing constituency upon constituency, sect upon sect basis requirement. Can the IBC respond to concerns like minority shareholders?
See, IBC is supposed to get into a resolution and a liquidation if resolution is not able to be achieved. So, in this process, some people will gain, some people will suffer. I don't think you can attend to each and everyone's, concerns in a particular law, which is supposed to take care of how to go through with this process and come to an end. There are bound to be people who are going to suffer. There are bound to be people who are going to gain. It's unthinkable how a law can address each and every one else's concern in the way it is structured, especially in a financial asset disposal. I don't know how this can be really, attempted.
Yeah, sure, Ashwin, please.
So on that point, again, not talking about any specific cases, but I think the securities regulators, SEBI, has waded into this debate finally, and the latest amendments that SEBI has come out with allow for a delisting so long as there is either an exit procedure or an exit price, and those price or procedure are set out in the resolution plan. Now, that's what the law says today.
So it's like some sort of minimum guarantee has now been woven into the process.
Look, yes, there's some sort of a minimum guarantee to the extent that, look, let's just recognize that when a firm goes into insolvency, then then as the Bankruptcy Law Reforms Committee report said, it is about creditors and their decision making is supreme. Now, unfortunately, in the waterfall and scheme of things, when a company is in insolvency, the shareholder is the bottom creditor.
Right.
So what the SEBI regulations have respected is that waterfall to say that shareholders must get at least as much as what they would have got.
Chance, just like home buyers were treated, that somebody will go to court and shareholders would be treated differently in the waterfall structure?
Look, I think it's a free country. Everybody.
Alok, is that possible?
It will be a very unfortunate outcome.
Okay. So I won't take sides on that. I just meant how would the courts approach such a question if it was posed to them?
I would say that because as a shareholder, you are a shareholder and you are aware that, as you very rightly said, you are at the bottom of the pile. And therefore, when you entered into shareholding agreement or you bought shares, you knew very well that if something...
You knew what the risks were.
What the risks were. It is very difficult to say once those risks have matured and have come out.
Yeah, exactly.
For you to want
the
to have
other
a
side of the
larger
argument
share.
will be, well, you
And
earned your
deprive-
dividends, you earned
and you
the
want to
higher
deprive
valuation
somebody.
benefits, so why cry about it? My last final point on today's show, and Mr. Gopalan, I'll come to you for that. The timely resolution and how key it is for banks. The macro point from this entire story that we are chasing on the NCLT, you know, while I respect the views that the law is not meant for recovery and it keeps coming up, the fact is that this is one of the biggest benefits we are seeing. I would argue, Mr. Gopalan, that the NCLT turnaround or the signs and resolution has reduced some of the pain that we are seeing in the PSU banking space. So the timely resolution, by some estimates, in FY19 will abate some of the asset quality concerns. Post-resolution, Mr. Gopalan, one of the estimates by CLSA says that the gross NPL ratio can come down to 5% from current 9% levels. And SBI alone, State Bank of India, NCLT 1 and 2 exposure of the State Bank of India, India's largest bank, is 78,000 crore. And even a 50% resolution of that will be massive good news if it were to happen, as it seems, in a quarter or two quarters. Other beneficiaries could be Punjab National Bank, Canara Bank, IDBI Bank, apart from SBI. So therefore, a final comment from you on today's show, Mr. Gopalan. What does this mean for the banking revival or banking coming back into the mainstream story? Apart from all other things that we have been discussing, the NCLT, is it going to prove to be a significant booster dose?
You have to look at it, the two sides to the coin in this. One is that the NCLT will certainly ensure that the NPAs are going to come down as far as the banks are involved in this case.
Right.
Please look at the other side, which is the capital for the banks. That has got to be provided by the government. With the public sector banks, at least, it has got to be provided by the government. So, if you look at the economy as a whole, I guess that, I mean, it's going to be the same thing as we go along. Somebody, I mean, gains, the banks gain, taxpayer loses, because the capital has to come from the taxpayer. So there is going to be a balance in this.
But this will at least reduce the need for capitalization funds.
Yeah, no. Capitalization will have to be there. Once the value gets eroded when you sell for a much lower price, obviously the provisioning will not be returned back as much as you would do in a 50% recovery comes. So for that, the capital has to be provided. Now, who provides the capital? The taxpayer. For the public sector banks, the taxpayer who is going to provide. That money could have been used for some better purpose.
Well, the taxpayer in India provides pretty much for everything, so, Mr. Gopalan.
Ultimately, the taxpayer who is going to foot the entire thing.
Absolutely. And to end this show, I want to play that chart out once again. The NCLT 1 status report, ladies and gentlemen, our viewers. And just, I'm going to go through those 12 companies, 12 months, and this is very, very significant. Bhushan Steel resolved 47,000 crore of debt. Electro Steel Steels 10,700. These are the two resolutions. There is a small caveat in the form of Electro Steel. It is subject to NCLT approval because the NCLT has reserved its verdict. ABG Shipyard, 16,000 crore in progress. Hopefully no liquidation there. Some signs or some reports source-based. Alok Industries, there has been a fresh development. 26,000 crore of principal debt right there. Hopefully something will happen. Amtech Auto, 12,500. There are other companies also along with it which are in NCLT, but Amtech was part of the NCLT 1, 12,500, close to $2 billion. Bhushan Power and Steel, a three-way face-off underway currently between Tata Steel, between JSW Steel and Liberty House. The Liberty House bid estimated pegged to be by sources better than Tata Steel. We will have to wait and watch whether Tata Steel will bag one more company or will it go the Liberty way, because remember, Liberty is also the leader as far as Amtech is concerned. Essar Steel, the big one, 44,000 crore. The world's largest steel maker, ArcelorMittal, has been in a painstaking battle with a Russian-backed consortium. We'll have to see whether London wins or whether the Russians who live in London will prevail as far as Essar Steel is concerned. JP Infra, hundreds and thousands of houses there. The Supreme Court monitoring that case. 13,000 crore of debt, but perhaps thrice that number of families impacted, and perhaps more than 1 lakh individuals stuck because of the lack of apartments. So in this case, this is an emotional case just like a few others. Jyoti Structures, 5,200, small change versus other numbers of debt if you look at that. But Lanco Infra, one more of those southern companies, infrastructure companies, politician-backed companies, which were the flavor of the season 10 years, 12 years back. Ladies and gentlemen, 40,000 crore and virtually no bidder. So that Lanco Infra should have been actually in red, given the quality of what is left in that company as per sources. And there are like a dozen or 2 dozen companies. The resolution professional and the lenders don't really know how to even come to grips with this problem. Forget good bids. Monet Ispat, steelmaker, back and forth, long drawn, but perhaps will get resolved, 9,500 crore. And Era Infra, which strangely managed to stay out of NCLT for the longest, just recently entered this process. So the 270-day deadline, still some several weeks left for that resolution. So that's the story of the 12 big companies, 3 lakh crore plus money that is stuck there of the banking system, and hopefully, if nothing else, at least a 1/3 recovery. That's what we are writing in as far as the write backs possible for banks are concerned at this point of time. With that, it's a wrap on this special episode of Mission Cleanup, 12 months, 12 companies. News and updates will continue on the other side. If you have, thank you very much for watching.